You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 66, How to Conduct a Patent Examiner Interview. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com. Or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state. So feel free to contact me regardless of where you live. In this episode, I'm going to talk about patent examiner interviews. You might be thinking that the examiner is your enemy, and sometimes it can feel like that if they keep rejecting your application. And sometimes maybe they do have some gripe against you, but believe me, they probably have so many patent applications on their desk that they don't have time to think of you as an enemy or have any personal vendetta against you. I'm sure it does happen, but that's really not the norm. In theory, you should be able to work with your examiner to find some common ground on what might be patentable about your invention. And sometimes it's hard to do that with just a written response because there's no give and take or answering questions on the spot. And in the examiner's response, they're not going to tell you ideas about how you might be able to get an allowance. They'll only tell you why the claims as they're written are either patentable or not patentable. If you look at the stats, applications where the patent attorney has conducted an interview with the examiner has a higher rate of allowance than applications where there's been no interview. The latest stats I've seen say that the overall allowance rate for a patent application without an interview is about 64%, and the overall allowance rate with an interview is about 80%. Not all examiners are equal as well. For some examiners, the interview might not have any effect on them, and for others, it might have a really high effect. But overall, they're a good thing. It doesn't cost anything to the patent office to do an interview, but if you're having an attorney do it, it will cost you attorney time to prepare and do the interview. So you do have to ask yourself whether getting a bump in the chance of allowance is worth another few $1,000s or whatever else your attorney charges for an interview. So what do you actually do for this interview? First, you usually want to wait until your first office action. You can't just file an application and request an interview at the same time. There has to be some kind of rejection. There is a pilot program where you can request an interview before you get a rejection, but if you're not doing the pilot program, the general rule is that you have to wait for a rejection. So what should you do for this interview? There are a few ways to do it, but I think the best way is to first call the examiner and probably call at least a month before the response is due for your rejection. You have to find a day that works for both you and the examiner, and oftentimes the examiner's supervisor will have to be in on the interview as well. There's also a form called the Automated Interview Request Form, and there's some boxes to check off. You might want to do another form where you authorize the patent office to communicate with you via the internet, so by email. So the examiner is allowed to email you instead of going through the patent filing system. And this form that you can fill out is called SB0439. In the form, you put in your name, application number, some other information about the patent application, your phone number, email, and you propose a few dates that will work. Since none of the dates and times that you propose on this form may work, that's why it's good to call first. But sometimes you're playing phone tag with the examiner and you just can't talk to them, so this automated request form is good if that happens. There's a really short video the patent office puts out, so if you search on the internet for schedule an interview with a patent examiner video, that should pop up. And then within 2 days, you should get an answer on when your interview is. There's also another form that's not an automatic form, but you should fill it out. And it's form PTOL 413A, which is called the Applicant-Initiated Interview Request Form. You fill out some information about the application, who will participate in the interview, proposed time and date, whether you want the interview to be just over the phone, a personal interview, but you probably would have to go to DC to do that, or a video conference, whether you're going to be demonstrating any exhibits, what issues you have with the rejection or objection, the claims, about the prior art that you might want to talk about. This really goes into more detail about what the interview is going to be about and not just setting up the date. You can, when you set up this video for a video conference, if you want to do that, you can find out more about that by going to uspto.gov/interview practice. After you fill out this form, the examiner is probably going to want you to write up an interview agenda, and you're going to send it usually by email directly to the examiner once you have authorized email communication. And you'll want to do this at least a few days before your actual interview so the examiner can review whatever you're submitting. If you're thinking about amending your claims, you probably want to write up some proposed changes that you're thinking about so the examiner can think about whether you're headed in the right direction to an allowance. You might want to focus on if the examiner is misinterpreting something in your claims in the prior art. If you think you're just going to argue for patentability and not make amendments, you might want to think about not submitting any proposed amendments, because if you include proposed amendments, maybe the examiner will be less likely to allow your claims as written and just pressure you into amending because knowing that you already made these proposals. They're really just different strategic approaches to how you want to do your interview. During the interview, you want to ask whether the examiner has any questions. It might be helpful to summarize the prior art, explain the invention, highlight the differences. Maybe you can say where you and the examiner agree, if you actually agree on certain points, and if there are any limitations in your claims that appear novel, or whether you think more amendments might be necessary. If the examiner says that they think the claim is too broad, try to pin down the examiner about what specifically is too broad based on the prior art. Before the interview ends, you try to confirm any agreement that you may have come to. The examiner is unlikely to give you any definitive answer on whether they'll allow it, especially if you made any claim amendments. The reason for this is that you just made claim amendments, so they have to review the amended claim, and there might be prior art out there that they haven't searched for based on how you previously wrote the claim. So they'll usually say something like, from what I've seen before, it doesn't look like this element is in the prior art, or it's not obvious over the prior art, but I'll have to conduct a new prior art search to be sure. You can ask the examiner to contact you again before if they decide to issue another rejection so that you can quickly respond without going through an official office action in response, especially if the examiner thinks that there might be some allowable subject matter. So after the interview, two things happen. There's an applicant interview summary and an examiner interview summary. You have to write a summary of the interview and record and file it with the patent office. If you're responding to an office action, you can include the interview summary with your office action response. There's no requirement for the formatting of the summary, but you need to accurately summarize the interview. Give the date, the names of the people who participated, whether an agreement was reached, and potentially any allowable subject matter, and whether the examiner agreed to contact you after the interview. The examiner will also write up an interview summary. You want to read that interview summary to make sure it's accurate, and you can ask for a corrected interview summary. Some people like to write up the interview summary for themselves right away, especially if it was a good interview, and really solidify the allowance in the examiner's mind. Other people like to wait for the examiner summary so you can address anything said in the interview and comment, as well as write about what your own interpretation of the interview summary. There's no rule on who has to go first, but just be aware of any deadlines you have with the patent office if you received a rejection. One other note about interviews is that the best time to do it is after the first office action, not the final office action. There's no requirement that the examiner has to allow an interview after the final office action. If you already filed an appeal brief, it's generally not allowed to have an interview. Also, there's generally only one interview allowed, and the examiner doesn't have to grant a second one. So if you didn't think something went well in the interview, you can't just request another interview. You can try, but it's likely not going to happen. What you will likely have to do is just file a response with a request for continued examination if it's a final office action. And then when you get another rejection and you file that response for the continued examination, then you can ask for another interview. Also, if you filed a continuation application, which I've talked about in previous episodes, you don't have to wait for a first rejection to request an interview. And this is because in practice, much of the invention has probably already been reviewed and some aspect has already been rejected. So when you file a continuation, there's lots of times when in practice, what you're really doing is responding to a rejection. And so it's okay to ask for an interview before your continuation application has been rejected. If you want to know all the nitty-gritty details about interview rules, you can search under the Manual of Patent Examining Procedure, Section 713. But that's basically what examiner interview is and how they can be useful. And if you want help with your patent application, responding to rejections, appeals, or anything else related to your invention, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.